My lords, revenue entry number 1537. My reply page 510, my lords. My lords, 510. Am I with my lords? This is revenue entry 1537. If I may be permitted to read. तारीख 28/12/56 श्री सरकार सर्वे number 18495051, then 52 is stricken off, 1907 नवा तथा so and so 1743 थी फैजल हरी आवता, and then this entry is certified on the right, my lords, on 25th of March 1958. So these lands were government lands, is what this entry reflects.
25th of March?
My lords, 1958. I've also put it in my affidavit, my lords.
Yes.
If my lords were to,
53 and 52 are not there in this.
we would come to that, Mr. Thakur. My lords may turn the page to 511 to solve Mr. Thakur's predicament. My lords, this is entry number 1538. तारीख 28/12/56 श्री सोमनाथ ट्रस्ट सर्वे नंबर 1852 नवो तथा 146 एकड़ 34 गुठा तेने खाते मापणी थई नक्की थया entry पड़ी, and this entry is also certified on 25th March 1958, my lords. Now, my lords, there is a significant acreage that may be noted by my lords. If my lord sees this entry at page 511, 146 acre, 34 gutha. While having 511 in hand, I pray my lords have 509, the government of Saurashtra notification. 2 pages prior, my lords. Item 4 that I had read to your ladyship, the acreage next to it, 146 acre, 34 gutha. So this is that very parcel, my lords, which is the waterfront land. My lords, a culmination of all these events, the pendency of the proceedings before the learned Waqf tribunal without any relief, the pendency of SCA 13449 of 24 before our Honorable High Court without any relief, and the rejection of the contempt petition by our Honorable Court on 9th of August, all has led to the actions which are taken in the month of September, where there is no relief available to the petitioners. Although some documents are shown by the petitioner, I may pray that my lords have the Rojkam that was carried out on the date when the petitioners consentingly agreed to demolition. Page 461. My lords, there are in all about 9 or 10 Rojkams, all of which are produced on record. The date at page 461 is 27/9/2024. My lords, the names of the individuals 1, 2, and 3. ये बताओ छो. ये petitioner number क्या है? My lords, 1 is Gohel Shakil Hussain Bhai, 2 is Salim Moti Bhai Dal, and 3 is Ahmad Rahman. My lords, on the left side, my lords would see signatures of these gentlemen. And if my lords were to turn the page to 460 to the operative portion, from the end of the third line, આ દરગાહનો બાંધકામ દૂર કરવા માટે જમીન મહેસૂલ અધિનિયમ કલમ 202 તલે દરગાહ પર આવેલ બિનઅધિકૃત બાંધકામ તત્કાલિક અસરથી દૂર કરવા માટે 5/9/24 ના રોજ નોટિસ લગાવવામાં આવેલ, જેથી આ બિનઅધિકૃત બાંધકામ તત્કાલિક અસરથી દૂર કરવા અમો રૂબરૂ જાણ કરેલ છે. ઉપરોક્ત હકીકત અમારા પંચો રૂબરૂ મિલકતના સ્થળે લખાવવામાં આવેલ છે, જેમાં ખાતરી બદલ અમો પંચો અમારા પૂરા હોશો હવાસમાં કે જે વિના દબાણ કોઈ પણ જાતના શેર શરમ વગર વાંચી સોએનસો સમજી વિચારી નીચે અમારી સહીઓ આપીએ છીએ. And these are the authorized signatories. Now, what becomes significant in one of these Panchrojkams is page 473. The third signatory, Isa Nur Muhammad, who I am instructed is one of the committee members of the Auliadin committee also.
Yes.
Therefore, the actions which culminated into the issuance of notice of 5th September, which was suppressed in the petition, was informed to the respondents on 27th September. On 27th September, contrary to what is contended by the petitioners, the persons who were authorized at the relevant places were taken into confidence. Their signatures were taken on the Panchrojkams, and only thereafter the exercise was carried out. Finally, in my respectful submission today, for a couple of reasons, few of them being that one, there is a waqf suit where there is no relief. There is a writ petition filed prior in point in time before our honorable court where there is no relief. There is a contempt petition that is decided, which specifically states that there is no interim protection. It has been accepted as on date by the petitioners. And the fact that the demolition exercise has been carried out, in my respectful submission, no interim relief may be granted in this petition. And my lords, just for my lords' reference, this is the news article of 10:09 a.m. today morning, which I was citing. Apone Thakur Sahib. If I may pray, my lords have the second page. This is what I had read out. Just below also read, respondents herein have carried out early morning so and so. Next paragraph, petitioner claims that the authorities in Gujarat violated the order dated 17th September. The matter is listed today before so and so. The petition has been filed through so and so, so and so. Therefore, in my respectful submission, when this is filed, known to the petitioners, this petition for that reason alone may not be considered by. I am grateful.
We got two things.
One branch or one has approached the Supreme Court.
But I am not aware of whether it is approached or not. This petition has to be decided on its own merits.
Sir, but when this issue, how is being
But I am not aware of it, first of all. This is a news which is there, which I also showed such a news, but this is also a news. Matter is already disposed of today.
please take instructions? Because
Certain-
if this very issue is now before the FX.
Lord, I will verify it.
Yes.
Lord, I will try to verify. But irrespective of whether that issue is there or not, Lord, this petition independently is required to be heard. One. Two, there is no answer given. The answer is given is threefold. No relief in Waqf suit. No relief, contempt petition rejected because there was no interim relief operating in the original suit or Waqf suit. And three, there is no relief in the earlier petition filed with respect to the transfer of the proceedings from one court to another. Assuming I'm going with my learned friend, there are no reliefs. Can they take action is not answered under 202 without any order under 179A, whether they can take action or not, nothing is answered. Whether they can take action in such a high-handed manner before 211 order, under 202, no answer. And all the 202 orders are in respect of constructions other than the masjids. Can they demolish the masjids? There is no answer. In the whole reply, there is no answer. An admitted position that the masjids are in existence since 1986 or 87. Admitted position. No, they are there much earlier, but on the record they are there. In 87, 89 order it is stated.
Is existing. You said the lease is in existence.
Masjid,
Masjid is-
masjid is in existence. And my lord, there are documents on record which I have produced of 1903 showing that this was given for the purpose of burial.
Yes.
Your lordship may have a look at that particular document, which is of 1903, that this land is given for burial. Page 100 is the document. Just for the, your lordship may go straight to 103, then I will read the typed copy. 103. તારીખ 28 માર્ચ 1903. Your lordship may then go straight to page 106. It is the typed copy.
106.
106. Typed copy of the same document. આ રાજ્યના તાબાના મહાલ પાટણના સદર સ્ટેશન પ્રભાસ પાટણમાં વસતી હિન્દુ અને મુસલમાન વતની વચમાં પોતે પોતાના ધર્મની જગ્યાઓ તથા તેની હદ તથા વપરાશની વહીવટ વગેરે સંબંધે જે શેર સમજૂતી ચાલતી હતી તેની તપાસ સને 1893 મહેરબાન કર્નલ J.M. હન્ટર સાહેબના પ્રમુખપણા નીચે કમિશન થી ઠરાવી તેમની ભલામણ અન્વયે ઠરાવ થયેલા છે. એ પછી સને 1896 માં બંને કોમના લોકો માહે માહે સમજૂતી ઘર મેળેનો ઠરાવ એ કોમના લોકોની સહી સાથેનો કબૂલાત થયો છે. આ ઠરાવની અલી ઝા ખુદાવંદ દૌલતમદાર નવાબ મંજૂર કરી તેની ધારાની યોગ્યતા આપી છે તથા તે પ્રમાણે અમલ થાય છે. This is the Nawab of Junagadh. સને 1893 માં મહેરબાન કર્નલ હન્ટર સાહેબના પ્રમુખપણા નીચે કમિશનની ભલામણ પાટણની મુસલમાન રૈયતના ઉપયોગ માટે કબ્રસ્તાનની જગ્યા મુકરર કરવા તથા તે ભલામણ અનુસરી શહેરના હિન્દુ મુસલમાન વચ્ચે સને 1896 સંવત 1952 માં થયેલા સમાધાન ઠરાવ કબૂલાત થયેલી છે કે મુસલમાન લોકોના કબ્રસ્તાન માટે અમુક જગ્યા મુકરર કરવા સંબંધમાં કમિશનની ભલામણ અનુસાર ખુદાવંદ દૌલતદાર નવાબ સાહેબ જે જગ્યા મુકરર કરવા ઠરાવ કરશે તે પ્રમાણે આપણે બંને પક્ષો લોકોએ વર્તવું. દરેક શહેર કસ્બાના ગામની વસ્તી રૈયતમાન લોકોને અવલ મંજલ માટે એક જગ્યા મુકરર કરવી પડે. એ સાર્વજનિક આરોગ્ય સુખ અને સગવડ તથા સુલેહ માટે જરૂરનું છે. તે વાત તેમજ ઉપરના પેરામાં બતાવેલી ભલામણ તથા કબૂલાત ધ્યાનમાં રાખી પ્રભાસ પાટણના વસતા મુસલમાનો માટે કબ્રસ્તાનની જગ્યા મુકરર કરવા વિચાર ચાલતો હતો. હાલમાં એ વિચાર પ્રમાણે કરવા કસ્બાના મુસલમાન કોમના આગેવાનો જોડે વાતચીત કરી તથા તેમની જોડેની વાતચીતની અલી ઝા ખુદાવંદ દૌલતદાર હજુર શ્રી માં જાહેર કરતા તેઓ સાહેબે ફરમાન કર્યું તે અનુસાર અમે પાટણ આવ્યા અને મજકૂર આગેવાનો મુસલમાનો સાથે રાખી પાટણ શહેરના તથા તેની બહાર આસપાસ ફર્યા અને બતાવવામાં આવી તે જગ્યા જોઈ સધરુ શહેરના મુસલમાન શહેરમાં તથા શહેર બહાર છૂટક જૂના કબ્રસ્તાનો છે તેની તથા એક સામાન્ય કબ્રસ્તાન તરીકે વાપરવા માટે તેઓની કબૂલાત આ સાથે જોડેલા નકશામાં બતાવેલી જગ્યા તે માહે લખેલી હદ પ્રમાણે તથા શરતો પ્રમાણે મુકરર કરવામાં આવે છે અને એવું ઠરાવવામાં આવે છે કે હવે પછી એ શરતો પ્રમાણે તથા મુકરર કરેલી હદની અનુસરી નહીં ચાલતા જે કોઈ તેનો ભંગ કરશે તે સાર્વજનિક હુકમના અપમાન ગુનેગાર ગણાશે તથા તે માટે ધારા પ્રમાણે સજાને પાત્ર થશે. સદ્રુ નકશામાં બતાવેલી કબ્રસ્તાન સિવાયની શહેરની અંદરની જે જગ્યા હાલની કોઈ પણ જમીન કોઈથી જૂનું નવું કબ્રસ્તાન કરવા વાપરવાનું થઈ શકશે નહીં. So this was the only કબ્રસ્તાન which was to be done. Then આ ઠરાવ અને તે સાથેના નકશો મુસલમાન લોકોને કબૂલ છે, તે માટે તેમના આગેવાનોની સહી લેવી ને પાટણની વસ્તી જાણ માટે પ્રસિદ્ધ થવા તે પ્રમાણે અમલ થવા પાટણ વહીવટદાર તથા પાટણ મુકસફ અને પોલીસ ફોજદારીની માહિતી માટે એક એના મુકાલતા ન્યાય માટે તથા પોલીસ ખાતા મોકલી આપી 28 માર્ચ 1903. Now, the plan is at page 105, 104. This is the area which was demarcated in 1903. And your lordship may go to page 110. Fifth column, typed copy, original is there above. Survey number, goal number પૈકી સર્વે નંબર 1853. ઉપરના નકશામાં બતાવેલી અને વર્ણવેલી કબ્રસ્તાન વાળી જગ્યા જે કોમના લોકોને હફન કરે એ તથા જે કોમના કબ્રસ્તાન દફન કર્યું છે તથા શહેર બહારના બંધ કરવામાં આવ્યા છે અને તેઓ તથા સાર્વજનિક મુસલમાન કોમના મહેથી તે જગ્યામાં દિવાન દફતર જાવક નંબર ડેશ થી ઠરાવથી દફન કરવાની છૂટ આપવામાં આવી છે. This is of 1903. Now, this is one fact. The factum is that till 2024, 28th of September, there were constructions. Under what power of law they have destroyed those constructions? 202 has to be preceded by an order. There is no order. Even if I don't have order, they cannot take law into their own hands. They've taken law into their own hands. 211 order is passed on 27/8. It is served on us on 30th, posted on 30th, dispatched on 30th. It is not even served. Till it is received by us, the order doesn't come into operation. In light of this, status quo is on today because it's already demolished, but status is on today and no wall should be constructed, that should be ordered.
My lords, there is only one decision of the Honorable Apex Court which may possibly
My lord,
govern the field.
My lord, this
my
is the
lords were to
petition
have-
which was filed in contempt petition filed in the Supreme Court.
With
I've got
respect
the
to
copy
Assam.
with respect to Assam.
My lords, this is order dated 29/9/2009, which in my respectful submission may be considered.
Yes.
My lord, short order, I may only read the first paragraph to give background. On 25th March 2008, this court took note of the newspaper item published in Times of India, Ahmedabad edition and passed the following order. Taking note of the fact in a news item published in so-and-so Ahmedabad edition dated 2nd May 2006, to the effect that 1200 so-and-so and 260 so-and-so had encroached on public spaces, the High Court of Gujarat at Ahmedabad, while taking suo motu action, issued notice to the 14 persons authorities who were arrayed as respondents. While doing so, the High Court gave the following interim directions. I may read the first quoted portion. Meanwhile, all the respondents are directed to take immediate steps for removal of encroachment of religious structures on the public spaces without any discrimination and submit their reports. I may skip this page and pray my lords have the next page, where the paragraph starts. Learned Solicitor General has brought to our notice a letter dated 19th September 2009, 23rd September 2009 of the Home Secretary, addressed to the Learned Solicitor General of India. The relevant portion of the letter reads as under. Please permit me to skip it because it will come in the directions on the penultimate page, the next page. My lords, the second unnumbered paragraph. As an interim measure, we direct that henceforth no unauthorized construction shall be carried out or permitted in the name of temple, church, mosque or gurudwara, etc. on public streets, public parks or other public places, etc. In respect of the unauthorized construction of religious nature which has already taken place. The state government and the union territory shall review the same on a case-to-case basis and take appropriate steps as expeditiously as possible. My submission, therefore, is that since October 2023, this has been happening, and today the question of status quo may not arise because the structures have been removed, and even my instructions are fencing is done, completed. The possession today is with the state government. I'm grateful.
Earlier in the past also there was any notice issued to the,
Please, my lords.
in past any notice was issued?
Please, my lords. My lords, page 320. The notice dated 7/10/2020.
3 2?
My lords, 320,
Acha, this is.
and which became subject matter of MCA 84 of 20. My lords.
We'll keep it tomorrow for orders.
This is not issued to any of the present applicants.
What?
Present 9 notices are not with respect to this particular structure.
So.
320. It is not with respect to any of the 9. And the hutments are, the notices are only with respect to hutmen, not with respect to Qabrastans.
And the petitioners are for what? Petitioners are there.
It is
That is factually untrue. Page 322, recorded by our honorable court, paragraph 3. Revenue number so and so popularly identified as Mangroli Shah Kabristan. Page 322, paragraph 3.
Petitioner is concerned with this.
My lords,
Well,
same
your
survey
lordship
number,
may just-
185.
your lordship may see
And that
the-
is why Mr. Hakim said yesterday they are in the process of challenging it.
Milord, your lordship may see page 320. I want your lordship to see.
No, whether this notice, according to you, this notice is not issued to the petitioner.
No, the 9 notices are issued to the parties whom petitioner is representing.
Or the petitioner?
Petitioner is a Waqaf.
Yes.
So Waqaf is representing the 9 parties as well as the masjids and dargahs which are there, Qabristan which are there.
Petitioners.
Petitioner.
Yes.
The Waqaf is representing all of them. This particular thing is in respect of one Banwa Khuda Baksh Abdul Hamid.
Mr. Thakur, according to you, this, you refer to that 1903.
Is for the Qabristan, 1852. Yes, 1853.
So in this PTR of petitioner trust, why that property is not?
Because it is not, look, there is a separate PTR. The lordship would have a look at.
Yes. Is this Qabristan shown?
It's not shown in the PTR.
Properties of the trust,
No,
in not a single.
no,
document?
it is not shown as a PTR.
In the proceedings before the Waqf.
My lord, annexure H may be seen.
In that proceedings before the tribunal.
Your lordship may see page 165, 166.
Page number?
165.
This is of Pir Shah Salah.
Yes, yes.
160?
5166.
Yes, what is this?
Pir Shah Salar Dargah, Rabas Patan. And there the survey numbers are mentioned 1850, 1851, 1852, acres 420.
What is this?
It's a PTR.
PTR of the petitioner,
No, of another trust,
not of the petitioner.
not of the petitioner. Petitioner trust, there are no lands.
And petitioner is agreed by what?
Agreed by the lands which are being taken away of the Qabristan which we are managing.
You say that there is no such land or Qabristan.
But that is not owned by the trust. We are not owning it, but it's running as a Qabristan. Well, the lordship appreciates the petitioners are managing the Qabristan. They are not owning the lands. I am not questioning the as a Waqaf.
As a Waqf.
Waqaf.
It is not a Waqf property. This Kabristan is not shown as a work of property.
It is not shown as a work of property because it's a government property.
The proceedings before the tribunal. Have you shown any support, based on record, any document or substantiation that you are managing this Kabristan or you are having the property?
All the proceedings are by us only throughout. Even the 87, 89.
Initiate the proceedings, but ultimately when a person is to initiate the proceedings, they have to show, substantiate that there's a.
But my lord, today, my lord, the issue is that there are constructions already existing there, were existing 3 days ago. They are being demolished. Can they do it without, even if I am an encroacher, can they do it without appropriate orders? And when I'm encroacher, let me put it, the parties are encroachers from 1988 or already on record. Can they do it? I am.
Mr. Thakur, you are not replying the court's here. Court is asking you, is in any of the PTRs or.
No, it is not there. I'm saying that. I'm saying that.
To your submission.
I am saying it is no, it is not there in the PTR.
About 61, about 79 capital. The court has understood.
No, I am
It is
saying.
trying to find out.
No,
whether
I am
you
not.
have been initiating proceedings.
I am initiating as an organization which is taking interest of the.
Petition is pending, no stay has been granted.
My lord,
Have you at any point of time?
I am
taken
not.
steps?
I am not showing the steps which are taken are 37 too.
No,
They are
that
there.
is- So the proceedings are pending.
Pending.
There is nothing.
Nothing, my lord. Nothing has happened except the status quo. Except the suit which was there, which is vacated.
Also, there was initially the order. but
No, it was there for 4 years.
In
I-
2020, 16th of January.
Yes, my lord.
2020, when the stay was vacated, did you take any steps for?
My lord, we have approached the Waqaf. No, we have gone and requested the Waqaf
But
court.
Mr. Mere request is not sufficient.
My lord, I agree, but my lord, my submission has therefore been that irrespective of whether I have got an order, can they take an action? That is my submission.
You are the petitioner, you are before this court.
Yes, but their action I am challenging today. I am challenging their action. As far as my concern, I will be pursuing the Waqaf court for getting appropriate orders.
Fortunately or fortunately from there, or unfortunately for you, action is already taken.
But already taken,
Action is already taken.
but the
Now you want the status quo to be that.
status quo is required to be maintained. My lord, your lordship, it will be handed over to somebody else. That is why the status quo. Otherwise, it will be handed over.
How you know that?
Because the lease is there of 999 years.
So, but what is there in offering that they are going to hand it over to?
Because therefore the state, my lord, today, my lord, they have demolished, unceremoniously demolished on 20th, without any authority of law taking the law into their hands. In my humble submission, they have demolished. Now, it is in this background that at least the status quo as on today is required to be maintained. I will take appropriate action in the Waqaf court to get an interim order. There, the court has adjourned on 11th October. The matter is there on 11th October. I'll argue before that court. But in the meanwhile, status quo is required to be maintained. And which is that notice for demolition of mosque? Not a single notice they are producing. They have only produced hutments outside the mosque on 202. Not a single notice in respect to dargah or mosque or of the Qabristan. Not a single notice. Only the huts outside the particular mosque or some adjoining to the mosque. Not a single document, and they've demolished everything. That's all. Can that be done? The issue is not what I have not done. The issue is, can the state take law into its own hands in this manner?
Yes, Mr. Is there any notice issued so far as the Qabristan is concerned?
My lords, these notices may have to be looked at holistically.
Just give us some straight reply.
Barring this, there is no other.
There are no notices, that's what. So without any notice, how you could have taken
My lords,
steps?
it is not that we have not issued any notice.
When you are targeting or when you are trying to take steps or action against X property, the notice has to be with respect to X property, right?
Yes.
For Y
That
property.
notice was issued in October 2023 itself. I'll
What
show
is
in a
that?
moment.
Qabristan,
Please, my lords.
where is that?
Please, my lords. 320 and then 322. Please see what was 320 and then please see
300 and
320, the notice date 7. So, my lords, this is one of those notices.
no, one of the notices.
Notices.
And for what purpose?
Lalan something something Abdul Hanif. Please see 322 for a moment. Paragraph 3.
Yes.
This is by the aforesaid order, temporary injunction was granted against the defendants, restraining them from
Mr. Vish, I am asking you, where is that notice issued for the purpose of removal of the dargah
My lords, I can
or the kabristan?
take instructions because here it says Mangroli Shah Kabristan. Please see, that is what I was wanting to show.
Where?
My 322, paragraph 3, it is recorded Mangroli Shah Kabristan. The last line, I may read. Revenue survey number 1852, popularly identified as Mangroli Shah Kabristan. So there would have been multiple notices issued on 7/10/2023, some of
No,
which,
but where is it?
my lord, because it was just one day, the petitioner has produced one notice. We endeavored to get all the records, but there was heavy rain in veraval.
Yes.
My lords may see 321. If Oliadin committee is before the honorable court in contempt jurisdiction, it is challenging for Mangroli Shah Kabristan. So there was some notice that was challenged. In fact, they would have the memo. I don't have the memo. I would get it. Paragraph 3 at 322. Please see the
interim order passed by the Supreme Court.
No, I am sorry that Mr. Thakur is wrong. Please see 321. The applicant before the honorable court in contempt jurisdiction is Oliadin committee through Muttawali Ismail Bhai Chel. And please see the challenge. The challenge is the notice dated so and so. By an order, temporary injunction was granted. Revenue survey popularly identified as Mangroli Shah Kabristan. And please see the subsequent portions of the order.
It appear to be pursuant to some notice issued.
It is. Allow me a moment, my lord. It is. In a moment, my lords. May I pray, my lords, have page 324.
Yes.
It is pursuant to this very notice at 320. I pray, my lords, have 324. Paragraph 4.7. It is, am I with my lords? It is submitted that despite the order dated 19/1/2016 injuncting respondent number 1 Collector Gir Somnath from interfering in any manner in the possession of the suit lands on 7/10/2023, that is 320, my lords, respondent number 1 Collector issued notices to the encroachers on the land survey number 1853 for immediately removing the makeshift hutments. It is submitted that on 8/10/2023, respondent number 1 Collector along with police protection removed the encroachments from the land and not only removed the encroachment but also caused damage to the graves. Further, on 9/10/23, respondent number 1 Collector constructed fencing within the land survey number 1853 and also put up a board declaring that the land survey number 1853 is a government land. If I may pray, my lords, turn 2 pages. 325 are the submissions of the state, my lords, and directly 329. Paragraph 7. Having heard learned advocates for the parties and having perused documents on record, it appears that the issue relates to land bearing Chalta number 26, revenue survey number 1853 at measuring 57 acre 1 gutha, and Chalta revenue survey number 1852 at measuring 1 acre 35 guthas of Prabhas Patan Taluka district Gir Somnath, which as per the revenue record is running as government land. On 28/4/2015, plaintiff numbers 1 to 6 stated to be trustees of.
This was dated 8th of October.
Please, my lords. The action, impugned action before the Honorable Contempt Court was 8th of October, page 324, para 4.8, my lords would have this date. Page 324, para 4.7.
This is the very.
Yes.
320 is the notice, Lord.
No, 324, what has been recorded?
Your Lordship may read paragraph. Your Lordship wants me to 4.7. That despite the order dated 19/1 injunctions, Somnath Collector Gir Somnath from interfering in any manner in the possession of the suit land on 7/10/2023, your Lordship may note the date. Now, Lordship may just go to page 320 for a minute.
What is this notice, Mr.?
Yeah, 320, I'm showing it.
Yes. Yes.
It is 7/10/2023. That's why I was connecting it. Now, Lordship, going back to that order, para 3.4.7.
Mr. Witness submitted that this was the notice which led to the.
Yes, my lord, for the contempt, Yes, your Lordship may read 4.
This notice should not have been issued.
Yes.
This notice is for the purpose of this petitioner to the.
No, your Lordship may read para 4.7 now further. Respondent issued notices to encroachers on the land bearing survey number 1853, immediately removing the makeshift hutments. Your Lordship has got.
What has been recorded in para 4.7, it says about the notice dated 7th of October 2023.
Yes,
That is page number 320,
correct.
right?
Mm.
According to you, this is not to the petitioner.
No,
This is not
not to the petition.
Then why the petitioner has initiated the contempt proceedings?
Because petitioner is a waqf, it initiates for everyone. It's not individuals who are initiating. Your Lordship may read 7.4.7 and 4.8 fully.
So it is not that you are not aware about the proceedings.
Yes, my lord, this notice is, but your Lordship may just read further. My lord, just read further. Is submitted despite order dated 19/1 Gir Somnath from interfering in any manner the possession of suit land. Respondent number 1 collector issued notices to encroachers. Notices. It's not one notice, more than one notice. I'm saying that. Encroachers on the land bearing survey number for removal makeshift
This
hutment.
Kabristan is over land bearing.
1852 and 1853. It is submitted that on 8/10/2023, your Lordship may note that 4.8.
Yes.
Respond number 1 collector along with police protection removed the encroachment from the land bearing and not only removed the encroachment but also caused damage to the graves. Further on 9/10, respond number constructed fencing within the land of 1853 and also put board declaring the land bearing as government land.
Yes.
Now this is the reason why the contempt was filed.
Yes.
Now today, this is not the notice which is relevant. That hutments have been removed.
After the contempt proceedings were disposed of, you did not take any purpose.
Lord, we are taking action in the Waqf court.
You are not taking these steps, Mr. Prabhu.
My lord, your Lordship will have to appreciate one fact, contempt.
See the effective steps taken by the Waqf this trust.
My lord, can I?
What is the date of this order? August 2024.
20. Yes, my lord.
Yes. Yes, and we are in October 2024.
Yes, my lord. And your Lordship may see what has.
Steps have been taken.
Your Lordship may note what has happened in the Waqf court. I will come to that in a minute. Now, my lord, what I am saying is that whatever has happened has been removed on that day. 7/10 notice and thereafter removal has happened. These are fresh notices issued under 202, and I am challenging these fresh notices.
Now, issue of challenge,
What?
has been these notices have been acted upon by them.
But if they have done it illegally, there has to be a stay of further action.
Now,
If-
what further action?
They will hand over the possession
Are
completely.
you going to position to end?
My lords, the fencing is completed. The fencing is completed. The property
Is it-
that has to be handed over to Sri Somnath Trust would go to Sri Somnath Trust.
Exactly.
Today it is
To the
government
trust.
land. To the trust, Sri Somnath Trust. Since 1950, its name is reflected.
Yes.
So it is not
There
the
is no
government
intent-
which is taking its
there is
action,
no
is taken to give it to Somnath Trust. Now, my lord, your Lordship will have to appreciate one fact.
Mm.
Can a high-handed action be taken to destroy things? 202 has to be preceded as per the full bench by a decision under 79A. There is no such decision. The whole action is high-handed, done, and even the masjids have, yes, and masjids have been demolished. Where is the provision for demolishing?
For orders tomorrow.
Monday, Wednesday, Thursday.
Grateful.
Appearing for other respondents who are the respondents of.
My lords.
Yeah.
My lords, I would appear for the state respondents. That would be 1, 2, 3, 4, and 5. 1 to 5.
And we are appearing for 6.
Grateful.
Admission.
Preparation for today. Supplementary board 3. Number 1 is Alpita Singh.
Okay,
Please.
the urgency.
I'll just broadly indicate what the problem is, because I am the petitioners are guarantors. There is a borrowing from 2 banks. Standard Chartered is one and Aditya Birla is another. My learned friends represent Aditya Birla.
Please,
Both the
Manoj.
bank,
I'm sorry, Manoj, I'm present online. I appear for the respondent time, Manoj.
so both have initiated action under SURFACE. I am aggrieved by page 674. The order by which my petition under section 94 has been dismissed. 674, even without issuance of notice.
7.
674. I am 14263.
Which matter?
14263.
14257.
There are
You
2
having
petitions.
The papers of
14263. 14263.
yeah, Bella. Ciao.
Second one, 674. Page 674 is the order.
6.
74.
Yes.
Heard Lords, it's passed dismissing petition under section 94 filed by the petitioner. Heard learned counsel for the applicants, learned counsel for the respondent appeared and waived notice. It is observed from the documents submitted and the submissions, and after hearing the respondent, that the applicant has given his personal guarantee being the director of the corporate debtor in favor of financial creditor. The corporate debtor and the directors have also filed a section 10 application, which is pending adjudication. The financial creditor has taken certain actions for recovery of the loan and issued demand notice to the corporate debtor and is not to be construed as invocation of guarantee. On the ground that this insolvency application is filed and moratorium has started, the applicant has prayed for certain release from the DRT, before whom the financial creditor has filed OA. No relief has been granted by DRT, but only it has noted that this application has been moved under section 94. It appears that it is clear that the application, being a director of the company, has prevented any action by the DRT and has also filed a section 10 application after SURFACE has been initiated by the financial creditor, and also filed an application under section 94 in personal capacity, having guaranteed the loan of the corporate debtor and as guarantor. The letter issued by the respondent is a demand notice to the corporate debtor and is not separate invocation of guarantee, as the directors and the company were individually responsible for repaying the loan. In view of the above, noting that the applicant has made an attempt to avoid repayment to financial creditor by both filing through the company and section 10 application and also a section 94 application under IBC, having guaranteed the loan, being the director of the corporate debtor without invoking the guarantee. In view of the above, the application is dismissed. Now, there are 3 fundamental issues here.
Yes.
Facts are that the borrower filed a section 10 petition for voluntary liquidation, which is pending. That process is on. The borrower has taken loan from two banks. One is Standard Chartered and second is Aditya Birla. As far as Standard Chartered is concerned, and that is where the NCLT has gone wrong. As far as Standard Chartered is concerned, Standard Chartered has already invoked the guarantee, which your lordships will find at page 315. So I will show factually, first of all, that there are three. At page 315, 2nd April 2024.
Yes.
This is a notice issued by lawyers to Rajashri Silk Mills Private Limited, which is the borrower, and 2 and 3 are the guarantors, 3 being the petitioner in the petition before the court. Now there is a reference to the facilities, and please see at page 316, recall come demand notice, etc. And then at page 317, there is a reference to the facility and there is a reference to the guarantee. Further, in terms of the said facility agreement, para 2 at 317. Said facility agreement, our client has disbursed a loan of 7 crore 70 lakhs, etc. And second term loan of so and so in favor of addressee company, wherein addressee 2, 3, and 4 stood as guarantors. As per the said facility, you are required to repay the dues pertaining to the said facility timely and regularly. Having referred to the guarantee, there is a demand at paragraph 5 that by means of the present notice, we on behalf of client hereby call upon you to repay the said amount of rupees so and so, along with future dues at prevailing interest so and so, so and so. So Standard Chartered has invoked the guarantee, called upon the guarantors to pay. So there is an invocation of guarantee. Now, because the error is that there is no, according to the NCLT order, the petition, this particular bank, Aditya Birla, has not invoked. But invocation can be by any. So if I want to invoke as a personal guarantor, if I want to file a petition under section 94, I may have multiple borrowings. Any one guarantor, once he invokes, I am entitled to approach under the IBC. I am entitled to approach the NCLT, and I have approached. So there is a reference to the guarantee. Now in my petition itself, kindly have a look at my petition.
So what is the order which has been passed by the tribunal?
But the tribunal has rejected at the very outset, without issuance of notice, the section 94 petition itself. And the Supreme Court says that at this stage, because what is the procedure under the IBC? Once the petition is filed, a resolution professional is appointed, who is then asked to submit a report. After submission of report at the stage of section 100, there will be an order of admission. At that stage, there can be an order of admission or rejection. But today, because the stage has not come, the petition comes up on board for the first time, they appear without notice, they waive notice, and they say that this is Aditya Birla, who's getting up. Therefore, kindly see, my petition at page 200. What is the form of that petition? I am the sole applicant at page 207. A person who applies goes, there is no respondent here. So what happens is that once I go there, immediately there is an appointment of RP. I will show the scheme of the provisions. The resolution, if your ladies kindly take up. Section 94 first.
So your application has been rejected by the tribunal.
At the
Threshold.
At the threshold, without calling for a report from the RP. That is what I wanted to show, Manoj. Section 94, first of all, a debtor who commits a default may apply either personally or through a resolution professional to the adjudicating authority for initiating the insolvency resolution process by submitting an application. That is 94. where the debtor is a partner of a firm, such debtor shall not apply, etc. So an application has to be submitted, shall be submitted, and subsection 3,
Yes.
an application under subsection 1 shall be submitted only in respect of debts which are not excluded debts. The debtor shall not be entitled to make an application under subsection if he is undischarged, etc., etc. So I qualified under 94. So there was no disqualification, and I qualified under 94. Now, once I file an application, please see section 96, which the court is aware, an interim moratorium kicks in immediately upon filing of the application. Then comes 97. If the application under section 94 or 95 is filed through a resolution professional, the adjudicating authority shall direct the board within 7 days of the date of the application to confirm that there are no disciplinary proceedings pending against the resolution professional. The board shall, within 7 days of receipt of direction, this will not apply in our case because it's not an application through a resolution professional. Now, subsection 3, when an application under 94 is filed by the debtor or the creditor himself, as the case may be, and not through resolution professional, the adjudicating authority shall direct the board within 7 days of the filing of such application to nominate a resolution professional for the insolvency resolution process. The board shall nominate a resolution professional within 10 days of receiving the direction issued by the adjudicating authority under subsection 3. The adjudicating authority shall by order appoint the resolution professional recommended under so-and-so as nominated by the board. A resolution professional appointed by the adjudicating authority shall be provided a copy. And then under 99, section 99, there is a report to be submitted by the resolution professional.
Your adjudicating authority.
It's NCLT. So under 99, then a report will have to be submitted, the resolution professional, which will contain all the details of the outstandings, etc. Now, once that report is received by the NCLT, under section 100, the matter will be considered for admission or rejection. It comes at the stage of 100, therefore kindly see 100. The adjudicating authority shall.
This order is not appealable.
But it is appealable. The problem is that this order was pronounced yesterday. It was uploaded yesterday, and today they have taken possession, acting under the Securitization Act, of 3 of the shops. But 2 things are happening parallelly. No, I understand, but because today I am here for immediate protection. But there are 2 contentions as far as alternative remedy is concerned. First and foremost, this order dismissing the application at this stage is an order completely without jurisdiction. Because the stage for admission or rejection will come only at the stage of section 100. Kindly have this judgment of the Honorable Supreme Court. Well, while considering the virus.
This is the conclusion, internal page 50, paragraph 86.
The provisions of this sections, the virus of this section was challenged. Jivraj, Dilip Jivraj.
Yes.
I will straight away go to the conclusion at internal page 50, paragraph 86.
Page number?
50, paragraph number 86, conclusion, so Roman 5.
Yes.
We summarize the conclusion of this judgment below. Now, 86.1 is important. No judicial adjudication is involved at the stages envisaged in section 95 to section 99 of IBC. So this order which is passed, under the scheme of the Act, once the petition is presented until the RPS report is received, there is no adjudicatory process involved. The Supreme Court says no judicial adjudication is involved at the stages envisaged in section 95 to section 99 of IBC. The judicial adjudication comes only at the stage of section 100. So once the RP report is submitted, and sir, what happens actually is that if I go,
This is what under 94.
this is 94 straight away. 95 is by a creditor, whereas 94 can be by the person concerned. So 94 is an application which is filed by the person concerned who is seeking insolvency by the debtor himself. So application by debtor to initiate insolvency resolution process, and 5 is application by creditor. So at the stage of 94 or 95, there is no adjudication required. Once there is an application under 94, 95, section 97 subsection 3 obliges, because there is the use of mandatory language. Section 97 subsection 3 obliges the adjudicating authority to approach the board for the appointment of the resolution professional. Once the resolution professional is appointed, the mandate is under 99, resolution professional will submit a report. And once the report is submitted under section 100, there will be an order of admission or rejection. So the admission or rejection of the application can happen only after there is a report of the resolution professional. Lot of sanctity is attached. So if the resolution professional were to opine that this does not require admission for whatever reasons, the tribunal will be justified in rejecting under section 100. And if admission is recommended, the tribunal will be justified in admitting. But before the appointment of resolution professional, and my problem is this, that securitization proceedings were initiated. So of 3 shops it is taken,
Yes,
for which I can claim repossession.
yes.
For other 6 or 7 secured properties, they have yet not taken possession. So,
Put the appellate tribunal.
but they are planning to take it tomorrow, Milos. I believe that statute must be permitted to operate. Please see what has happened. Sir, as far as Aditya Birla is concerned, the account was declared as an NPA only in May 2024, on 3rd of May 2024. They immediately issued a notice on 8th of May 2024 under the surfacing. After rejecting our objections, they took symbolic possession on 18/7/24, 18 July 2024. We have filed one essay. The essay is pending. Pending essay, they applied under section 14. That application is made and immediately an order is passed under section 14. That order is passed on 5th of September 2024. Everything is happening in quick succession. So order is passed on 5th September 24. The commissioner gave a notice on 12th September 24. So we filed an IA in the DRT proceedings for stay of proceedings. Now please see the order which is passed by the DRT at page 667.
667.
667. And the relevant paragraph is 11 at page 673. So I go to DRT. By this time, I already filed a section 94 petition. So I go to DRT to point out that I have filed section 94. Please see, in view of the aforesaid law laid down by the Honorable Apex Court, I am of the prima facie view that moratorium under section 96 of IBC operates on an application filed by the personal guarantor. However, admittedly, no order has been passed by NCLT under section 14. So far as interim moratorium under section 96 of IBC is concerned, as observed by the Honorable Supreme Court in para 57, filing of an application under 94 and 95 triggers interim moratorium, and its effect is that a legal action or proceeding pending in respect of any debt is deemed to have been stayed, and it is by virtue of operation of law. Hence, this tribunal does not deem it fit to pass any specific order in respect of the impugned action, but both the parties to the proceedings are expected to follow consequences of law as contained in section 96 and as observed by the Honorable Supreme Court. So they deferred the possession. They deferred. That happens on 12th. Then this application comes up 26th, I'm sorry. So the DRT order is on 26th 9/2024. On the next day or day thereafter, they were planning to take possession. So because of this order, they deferred the taking of possession. Thereafter, this matter comes up before the NCLT, and after it was heard, this order is passed on 27/9/2024. So immediately next day after the DRT order, this order is passed. But this order was uploaded only on Monday. So it was passed on Friday, not made available on Saturday, Sunday. Sunday was the date for taking possession. They deferred it because of the pendency of 94 in view of the DRT order. On Monday, the order is uploaded. And on Tuesday, first thing in the morning today, they have taken possession. Yesterday in the evening, the order is uploaded. And they have already taken possession of 3 shops without any fresh notice, without any further intimation. Now, this order, in my respectful submission, is clearly erroneous for a variety of reasons. Because first and foremost, this is not at the stage at which the DRT can, NCLT can reject the application. The only thing which NCLT can do at this stage is call for RP's report. After RP's report under section 100, it can either admit or reject. That is the first submission.